Chapter XIX, Defenses, SS 286. As to defenses, the principal defenses interposed in suits prosecuted to annul fraudulent transfers, as is elsewhere shown, are that the purchaser acquired the title or property bona fide without notice of or participation in the grantor's fraudulent intent, and that adequate consideration was paid or given for it. The principles and authorities governing these branches of our investigation have been considered of sufficient moment to call for treatment in separate chapters, and need not be again discussed. But there are certain lines of defense common to this class of litigation which command at least passing attention. It may be observed at the outset that the fact that forms of law have been pursued is no protection in a court of equity. If the result aimed at and reached is a fraud, the transaction must be judged by its real character, rather than by the form and color which the parties have seen fit to give it. What cannot be done directly cannot be done by indirection. And when fraud appears, the forms will be discarded and the corrupt act exposed and punished. SS 286A. Another action pending. The general and salutary principle of procedure that no person shall be twice vexed for the same cause, of course applies to proceedings instituted by creditors. Thus, in a case which arose in Pennsylvania where a creditor's bill was filed against directors of an insolvent bank charging mismanagement of its affairs, and an assignee of the bank subsequently brought an action at law in the name of the bank against the directors for the same cause, it was held that the pendency of the bill was well pleaded in abatement in the action at law. SS 287. Lashes. We have elsewhere discussed the cases relating to the sufficiency of pleas excusing apparent lashes in filing a bill to annul a fraudulent transfer, endeavoring to avoid unnecessary repetition. Let us recur to the subject of lashes considered as a defense or bar to a suit. Courts of equity do not impute lashes by an iron rule. Circumstances are allowed to govern every case. It may be asserted at the outset that equity will not be moved to set aside a fraudulent transaction at the suit of one who, after he had knowledge of the fraud, or after he was put upon inquiry with the means of knowledge accessible to him, has been quiescent during a period longer than that fixed by the statute of limitations. A stale and uncertain demand, as for instance, a bill filed to set aside an alleged fraudulent conveyance 19 years old, should not be allowed in a court of equity. In Eigelberger v. Kibler, it appeared that the complainant had permitted the conveyance in question to stand for nearly 10 years. During which period many valuable improvements had been made by the grantee, and the creditor had also suffered other creditors, junior in date to him, to acquire prior liens, and thus consumed the estate of the debtor. Upon this state of facts, the court very properly decided that the creditor, having by his supineness allowed the fund to be taken away, could not subsequently be permitted to make his own lashes a ground of injury to another. So it has been considered an important element that the transactions out of which the suit arose commenced about 13 years before any attempt was made toward impeachment, and no efforts at concealment or secrecy were shown. After such delay, said Chief Justice Waite, we are not inclined to set aside what has been permitted to remain so long undisturbed, simply because of an inability to explain with exact certainty from what precise source the money came, which went into the purchase of each particular parcel of property. Chancellor Kent said, there is no principle better established in this court, nor one founded on more solid considerations of equity and public utility, than that which declares that if one man, knowingly, though he does it passively, by looking on, suffers another to purchase and expend money on land, under an erroneous opinion of title, without making known his claim, he shall not afterwards be permitted to exercise his legal right against such person. It would be an act of fraud and injustice, and his conscience is bound by this equitable estoppel. The Court of Appeals of New York could see no reason why the same principle should not protect creditors, who have given credit upon the faith of the apparent ownership of property and possession of the debtor, against a secret unrecorded conveyance, fraudulently concealed by the grantee, as when, with knowledge that the debtor is holding himself out as owner, and is gaining credit upon this ground, he keeps silence, giving no sign. But in this latter case, the creditor's suit failed because of his lashes in not examining the record, and because of a lack of evidence of knowledge of circumstances which called upon the defendant to record his deed. SS 288. Lapse of time. The general principle of equity jurisprudence, that lapse of time, independent of limitations or simple lashes, may constitute a defense to a suit, is ably considered by McCrary, J., in United States v. B.B. in an action brought to annul fraudulent patents. The court says in substance that the authorities support the proposition that lapse of time may be a good defense in equity, independently of any statute of limitations, and they show that the doctrine rests not alone upon lashes. It is often put upon one or all of the following grounds. Namely, first, that courts of equity must, for the peace of society, and upon grounds of public policy, discourage stale demands by refusing to entertain them. Second, that lapse of time will, if long enough, be regarded as evidence against the stale claim, equal to that of credible witnesses, and which, being disregarded, would in a majority of cases lead to unjust judgments. Third, that, after the witnesses who had personal knowledge of the facts have all passed away, it is impossible to ascertain the facts, and courts of equity will, on this ground, refuse to undertake such a task. Thus Mr. Justice Story says, a defense peculiar to courts of equity is founded upon the mere lapse of time, and the staleness of the claim, in cases where no statute of limitations directly governs the case. In such cases, courts of equity act sometimes by analogy to the law, and sometimes act upon their own inherent doctrine of discouraging, for the peace of society, antiquated demands, by refusing to interfere when there has been gross lashes in prosecuting rights, or long and unreasonable acquiescence in the assertion of adverse rights. And in Maxwell v. Kennedy, the Supreme Court of the United States, in answer to the argument that there was no statute of limitations applicable to the case at bar, said, "We think the lapse of time, upon the facts stated in the bill and exhibits, is, upon principles of equity, a bar to the relief prayed, without reference to the direct bar of a statute of limitations." SS 289. Again, in Clark v. Borman's Executors, the same court observed, every principle of justice and fair dealing, of the security of rights long recognized, of repose of society, and the intelligent administration of justice, forbids us to enter upon an inquiry into that transaction 40 years after it occurred, when all the parties interested have lived and died without complaining of it, upon the suggestion of a construction of the will different from that held by the parties concerned, and acquiesced in by them through all this time. In Brown v. County of Buena Vista, the doctrine is expressed in these words: the lapse of time carries with it the memory and life of witnesses, the muniments of evidence, and other means of proof. The rule which gives it the effect prescribed is necessary to the peace, repose, and welfare of society. A departure from it would open an inlet to the evils intended to be excluded. In Harwood v. Railroad Co., the principle is concisely and clearly stated thus, without reference to any statute of limitations. The courts have adopted the principle that the delay which will defeat a recovery must depend upon the particular circumstances of each case. Lord Redesdale observed, "It is said that courts of equity are not within the statute of limitation. This is true in one respect: they are not within the words of the statutes, because the words apply to particular legal remedies. But they are within the spirit and meaning of the statutes, and have been always so considered." Important discussions of this general principle may be found in Elmendorf v. Taylor and Badger v. Badger. In Boone v. Chiles, the rule is thus laid down: a court of chancery is said to act on its own rules in regard to stale demands, and independent of the statute, it will refuse to give relief where a party has long slept on his rights, and where the possession of the property claimed has been held in good faith, without disturbance, and has greatly increased in value. In Wilson v. Anthony, cited with approval by the Supreme Court of the United States in Sullivan v. Portland, etc., R.R. Co., the doctrine is well stated thus: the Chancellor refuses to interfere after an unreasonable lapse of time from considerations of public policy, and from the difficulty of doing entire justice when the original transactions have become obscured by time and the evidence may be lost. SS 290. Discovery of the fraud. It is a general rule that where the party injured by the fraud remains in ignorance of it, without any fault or want of care on his part, the statute does not begin to run until the fraud is discovered by, or becomes known to the party suing, or those in privity with him, to hold that by concealing a fraud, says Miller, J., or by committing a fraud in a manner that it concealed itself until such time as the party committing the fraud could plead the statute of limitations to protect it, is to make the law which was designed to prevent fraud the means by which it is made successful and secure. This, as we have already shown, is a rule of pleading, as well as a matter of evidence or of defense. SS 291. Judge Blatchford's views. This subject was ably discussed in Tyler v. Angevine by Blatchford, J. While a circuit judge, he said, in suits in equity, the decided weight of authority is in favor of the proposition that where the party injured by the fraud remains in ignorance of it without any fault or want of diligence or care on his part. The bar of the statute does not begin to run until the fraud is discovered, though there be no special circumstances or efforts, on the part of the party committing the fraud, to conceal it from the knowledge of the other party, on the question as it arises in actions at law. There is, in this country, a very decided conflict of authority. Many of the courts hold that the rule is sustained in courts of equity only on the ground that these courts are not bound by the mere force of the statute, as courts of common law are, but only as they have adopted its principle as expressing their own rule of applying the doctrine of lashes in analogous cases. They, therefore, make concealed fraud an exception on purely equitable principles. On the other hand, the English courts, and the courts of Connecticut, Massachusetts, Pennsylvania, and others of great respectability, hold that the doctrine is equally applicable to cases at law, as the case before us is a suit in equity. And as the bill contains a distinct allegation that the defendants kept secret and concealed from the parties interested the fraud which is sought to be redressed, we might rest this case on what we have said is the undisputed doctrine of the courts of equity. But for the peculiar language of the statute we are considering, we cannot say, in regard to this act of limitations, that courts of equity are not bound by its terms, for its very words are, that no suit at law or in equity shall in any case be maintained unless brought within 2 years, etc. It is quite clear that this statute must be held to apply equally, by its own force, to courts of equity and to courts of law, and, if there be an exception to the universality of its language, it must be one which applies, under the same state of facts, to suits at law as well as to suits in equity. And we are also of opinion that this is founded in a sound and philosophical view of the principles of the statute of limitations. They were enacted to prevent frauds, to prevent parties from asserting rights after the lapse of time had destroyed or impaired the evidence which would show that such rights never existed, or had been satisfied, transferred, or extinguished, if they ever did exist, to hold that, by concealing a fraud, or by committing a fraud in a manner that it concealed itself, until such time as the party committing the fraud could plead the statute of limitations to protect it, is to make the law which was designed to prevent fraud the means by which it is made successful and secure. Mr. Justice Harlan has said, "It is an established rule of equity, as administered in the courts of the United States, that, where relief is asked on the ground of actual fraud, especially if such fraud has been concealed, time will not run in favor of the defendant until the discovery of the fraud, or until, with reasonable diligence, it might have been discovered." SS 292, Statute of Limitations. It follows then, that as to a creditor who seeks to impeach a deed made by his debtor conveying real estate to a third person in fraud of his creditors, the statute of limitations, when applicable, begins to run from the time the fraudulent deed is recorded, or from the time the creditor has actual notice of the conveyance. Whichever first occurs, it is familiar learning that in the absence of a contrary rule established by statute, a defendant who desires to avail himself of a statute of limitations as a defense must raise the question either in pleading, or on the trial, or before judgment. 10 years adverse possession is a good defense in Alabama to a suit to set aside a deed as fraudulent. SS 293, Limitations in Equity. In the consideration of purely equitable rights, entitles courts of equity act in analogy to the statute of limitations, but are not bound by it, as was said in the case of Hall v. Russell. When an action upon a legal title to land would be barred by the statute, courts of equity will apply a like limitation to suits founded upon equitable rights to the same property. So, in cases of implied or constructive trust, where it is sought, for the purpose of maintaining the remedy, to force upon the defendant the character of trustee, courts will apply the same limitation as provided for actions at law. SS 294, Insolvency or bankruptcy discharges. The insolvent laws of a state have no extraterritorial force. They affect only contracts between citizens of the state in which such laws were enacted, as was tersely stated in Cook v. Moffat. A certificate of discharge will not bar an action brought by a citizen of another state on a contract with him. Such was the conclusion of the Supreme Court of Maine in Felch v. Bugby, where this question is most carefully examined, and in Baldwin v. Hale, citing that case with approbation. The court decided that a discharge under the insolvent law of one state was not a bar to an action on a note given and payable in the same state, the party to whom the note was given being a resident of a different state, and not having proved his debt against the defendant's estate in insolvency. nor in any manner having been a party to the proceedings. In Pratt v. Chase, it is said that as to creditors of the insolvent who are not citizens of the same state where the discharge is granted, the one of binding force to defeat the obligation of a contract is founded upon the one of jurisdiction over such creditors. ISO. A debt contracted and payable in a foreign country is not barred by a discharge under the United States Bankrupt Act, where the creditor was not a party to and had no personal notice of the proceedings in bankruptcy. The discharge of the debtor is not necessarily a bar to the creditor's proceedings to reach property fraudulently alienated. Thus in State v. Williams it appeared that A, having made a fraudulent conveyance of his real estate, was afterwards sued by B during the pendency of the suit. A filed his petition in bankruptcy and obtained his discharge before judgment was had against him. Afterward B filed a bill to set aside the fraudulent conveyance and to subject the property to the payment of the judgment against her. The court held that the discharge in bankruptcy was no bar to the proceeding. The creditor's proceedings are quasi in rem. SS 295. Existing and subsequent creditors. It is said in But Compare Murray v. Rottenham, interposed as a defense to any action Collins v. Nelson, that in a suit by a creditor to set aside a conveyance of real estate, alleged to have been executed by his debtor for the fraudulent purpose of cheating, hindering, and delaying the creditor in the collection of the debtor's indebtedness to him. The answer of the debtor, to the effect that, at the time of the commencement of the suit, no part of his indebtedness to the creditor was due and unpaid, will constitute a complete defense and bar of such suit. The statement is, it seems to us, misleading, as is elsewhere shown. Subsequent creditors may attack conveyances made with the intention to avoid future liabilities, or to place the risks of new ventures and speculations upon the creditor's shoulders. SS 296. Sufficient property left. Gift of land. The general rule applicable to conveyances of both real and personal property, as announced by the Supreme Court of Indiana, is that a sale cannot be impeached as fraudulent unless it is shown that the debtor had no other property subject to execution at the time the conveyance was made. This, it seems, is also a rule of pleading, where a father, in solvent circumstances, made an oral gift of land to his son, who entered into possession and made lasting improvements on it. The latter was considered to have a good title as against creditors of the father, taking possession under a parole agreement with the consent of the vendor, accompanied with other acts which cannot be recalled so as to place the party taking possession in the same situation that he previously occupied, has always been held to take such agreement out of the operation of the statute of frauds. SS 297. What sheriff must show against stranger, as a general rule process regular on its face, and issued by a tribunal or officer having authority to issue it, is sufficient to protect the officer, although it may have been irregularly issued. But when an officer attempts to overthrow a sale by the debtor on the ground that it was fraudulent as to creditors, he must go back of his process and show the authority for issuing it. If he acts under an execution, he must show a judgment, and if he seizes under an attachment, he must show the attachment regularly issued.